So today we are going to discuss Panchayati Raj system in India. In our lecture we will cover the following aspects: 73rd Constitutional Amendment Act 1992, कुछ important constitutional provisions, the Panchayats which will include three-tier Panchayati Raj system, Gram Sabha, constitution of Panchayats, reservation of seats in Panchayat, the duration of Panchayat, powers, authority and responsibility vested in Panchayats, State Finance Commission and State Election Commission. So we will begin with an introductory note. The Constitution's 73rd Amendment Act added a new part, that is part 9 to the Constitution of India. It included 16 articles and the 11th schedule was also added to the Constitution. The 73rd Amendment Act envisaged the Gram Sabha as the foundation of Panchayati Raj system to perform functions and powers entrusted it to it by the state legislative assemblies. The amendment provides for a three-tier Panchayati Raj system at the village, intermediate and district levels. Small states with the population of about 20 lakhs, मतलब छोटे states जहां पर जनसंख्या केवल 20 लाख तक की है, would have been given the option not to constitute panchayat at the intermediate level, that is, they could constitute a two-tier Panchayati Raj system. The act provides that the panchayat bodies will have an assured duration of 5 years with election mandatory after this period. लेकिन एक बात गौर करने की है, it is to be noted that under the Amendment Act, the establishment of the panchayats and devolution of necessary powers and authority on the Panchayati Raj institutions are vested in the state government. यह सारी जिम्मेदारी राज्य सरकारों की है. So in this view, it can be said that the success of Panchayati Raj institutions as a unit of democracy and thereby ushering an all-round development of rural areas will depend much upon the intentions of respective state governments. So as we all know that Part 9 and Part 9A were added to the Constitution by the Constitution 73rd Amendment Act 1992 and the 74th Amendment Act 1992. Therefore, they are popularly known as Panchayati Raj and Nagar Palika Constitution Amendment Acts. Both of them provided constitutional sanction to the democracy at grassroots level. The Panchayati Raj and Nagar Palika Constitution Amendment Act provided the constitutional guarantee to basic and essential features of self-governing democratic institutions in rural and urban areas, including regular election to panchayats, reservation of seats to them, reservation of women and devolution of certain financial and administrative powers to them. Thereby, यहाँ पर हम एक और एस्पेक्ट को टच करेंगे जहाँ पर the passing of the 73rd and 74th Constitutional Amendment Act are in consistency with Article 40 of the Constitution of India, that is the Directive Principles of State Policy, which allows the state to take steps to organize village panchayats and endow them with such powers and authority as may be necessary for them to function as units of self-government. Now, starting with Gram Sabha, we will discuss the salient aspects of the Panchayati Raj institutions in India as well as the constitutional provisions pertaining to it. So, what do you mean by a Gram Sabha? A Gram Sabha is defined under Article 243 subclause B of the Constitution. It means a body constituting of persons registered in the electoral rolls relating to a village comprised within the area of panchayat at the village level. So it is basically the primary body of the Panchayati Raj system and by far the largest body. It is a permanent body. इसे ही अगर हिंदी में समझा जाए तो ग्राम सभा पंचायती राज की एक मूल संस्था है. पंचायती राज की अन्य संस्थाएं जैसे ग्राम पंचायत, ग्राम कचहरी या पंचायत समिति एवं जिला परिषद जनता के प्रतिनिधियों वाली संस्था है, किंतु ग्राम सभा स्वयं जनता की एक सभा है. ग्राम सभा का क्षेत्र एक राजस्व ग्राम होता है, किंतु बड़े राजस्व ग्रामों में जहां एक से अधिक ग्राम पंचायत का गठन हुआ हो, वहां जितनी ग्राम पंचायतें होंगी उन सब की एक अलग अलग ग्राम सभा होती है. ग्राम सभा किसी एक गांव या पंचायत का चुनाव कराने वाले गांवों के समूह की मतदाता सूची में शामिल सभी व्यक्तियों से मिलकर एक बनी हुई संस्था है. अतः हम यह कह सकते हैं किसी ग्राम की निर्वाचित नामावली में जो नाम दर्ज होते हैं उन व्यक्तियों को सामूहिक रूप से ग्राम सभा कहा जाता है. Article 243A provides that the Gram Sabha may exercise such powers and function and perform such functions at the village level as the legislature of a state may by law provide. Therefore, हम कह सकते हैं कि ग्राम सभा क्या काम करेंगी यह सुनिश्चित करना राज्य शासन का काम है. The 73rd Amendment Act thus envisages the Gram Sabha as the foundation of Panchayati Raj system, and Gram Sabha means a body, as I have already told you, consisting of persons registered in the electoral rolls relating to a village comprised within the area of panchayat at the village level. अब हम देखेंगे the Constitution of Panchayat. So, Article 243B visualizes a three-tier Panchayati Raj system in India. एक त्रिस्तरीय प्रणाली की परिकल्पना की हुई है. It provides that इन एवरी स्टेट, हर स्टेट में देयर शैल बी कॉन्स्टिट्यूटेड पंचायत एट विलेज, इंटरमीडिएट एंड डिस्ट्रिक्ट लेवल, यानी कि विलेज, इंटरमीडिएट और डिस्ट्रिक्ट लेवल पर हर राज्य में पंचायती राज इंस्टीट्यूशंस का गठन किया जाएगा। However, small states having population of not exceeding 20 lakhs, यानी कि वह राज्य जिनकी जनसंख्या 20 लाख से कम है, they have been given an option not to constitute panchayats at the intermediate level. We will now look at the composition of panchayats. So, Article 243C provides that state legislature may by law make provision with respect to composition of panchayat. However, while making such law, the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall, so far as be practical, be same throughout the state. At the same time, all seats in the panchayat shall be filled by person chosen by direct election, यानी कि पंचायत इलेक्शन हमेशा डायरेक्ट होंगे from the territorial constituencies in the पंचायत area. For this purpose, इस पर्पस के लिए पंचायतों को टेरिटोरियल कॉन्स्टिट्यूएंसी में डिवाइड किया जाएगा. Now, the legislature of a state may also provide for representation of certain functionaries in the panchayat systems. पहला है चेयरपर्सन ऑफ पंचायत एट विलेज लेवल. इन्हें पंचायत एट इंटरमीडिएट लेवल में रिप्रेजेंटेशन के संदर्भ में कानून बनाया जा सकता है. इसी प्रकार चेयरपर्सन ऑफ पंचायत एट इंटरमीडिएट लेवल को डिस्ट्रिक्ट लेवल की पंचायत में रिप्रेजेंटेशन के संबंध में प्रावधान बनाया जा सकता है. इसके साथ साथ विधायक, लोकसभा या राज्यसभा के सांसदों को भी विलेज लेवल को छोड़कर किसी भी लेवल के पंचायत इंस्टीट्यूशन में रिप्रेजेंटेशन के संदर्भ में प्रावधान बनाया जा सकता है. अब हम आरक्षण संबंधी उपबंध पर दृष्टि डालेंगे. So, according to Article 243D, in every panchayat, seats shall be reserved for scheduled caste and scheduled tribes, and the number of seats so reserved shall be as nearly as may be in the same proportion to the total number of seats to be filled by direct election in that panchayat, as the population of scheduled caste and scheduled tribe in that panchayat area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a panchayat. इसका अर्थ है कि प्रत्येक पंचायत में अनुसूचित जाति तथा अनुसूचित जनजातियों के लिए सीटों का आरक्षण होगा और यह सीटों का आरक्षण उस पंचायत क्षेत्र में उनकी कुल जनसंख्या के आधार पर होगा. Apart from this, out of the total number of seats filled by direct election in every panchayat, not less than, including those seats reserved for SC and ST, seats shall be reserved for women. अगर पंचायत की ड्यूरेशन की बात करें तो आर्टिकल 243E के अनुसार पंचायत का कार्यकाल 5 वर्षों का होगा एंड एन इलेक्शन टू कॉन्स्टिट्यूट अ पंचायत मस्ट बी कंप्लीटेड बिफोर द एक्सपायरी ऑफ इट्स ड्यूरेशन और इफ इट इज डिसॉल्व्ड देन बिफोर द एक्सपायरेशन ऑफ 6 months फ्रॉम द डेट ऑफ इट्स डिसॉल्यूशन. We will now discuss power, authority and responsibility vested in the panchayat. The constitutional provision related to it is Article 243G. It states that state legislature may by law endow the panchayat with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a law, इस प्रकार का कानून may contain provision for the devolution of powers and responsibility upon पंचायत subject to such conditions as may be specified therein and with respect to, यानी कि इस संबंध में अगर राज्य विधायिका कोई कानून पारित करती है तो निम्न मुद्दों पर वह कानून हो सकता है. पहला, द प्रिपरेशन ऑफ प्लान्स फॉर इकोनॉमिक डेवलपमेंट एंड सोशल जस्टिस. दूसरा, implementations of schemes for social development and social justice as listed under 11th schedule, यानी कि 11वीं अनुसूची संविधान की जो है उसके अंतर्गत जो भी मुद्दे आते हैं उस संबंध में पावर्स, अथॉरिटी या रिस्पॉन्सिबिलिटी राज्य शासन कानून बनाकर पंचायतों को दे सकती है. सम ऑफ द मैटर्स लिस्टेड इन द 11th शेड्यूल आर एग्रीकल्चर इंक्लूडिंग एग्रीकल्चर एक्सटेंशन, लैंड इंप्रूवमेंट, माइनर इरिगेशन, वाटर मैनेजमेंट, वाटरशेड डेवलपमेंट, एनिमल हस्बेंड्री, डेयरी, पोल्ट्री, फिशरी, सोशल फॉरेस्ट्री एंड फार्म फॉरेस्ट्री, माइनर फॉरेस्ट प्रोड्यूस और बहुत सारे ऐसे प्रोविजन आप 11वीं अनुसूची में जाकर इन्हें देख सकते हैं. Article 243H empowers a state legislature to authorize panchayat to levy, collect and appropriate certain taxes, duties, tolls and fees. It also enables the state legislature to assign to a panchayat such taxes, duty, tolls, and it also provides for making grant and aids to the panchayat from the consolidated fund of the state. अब हम दृष्टि डालेंगे राज्य वित्त आयोग पर. It is established under Article 243I and it provides for establishment of a finance commission for reviewing financial position of panchayat. It is appointed by the governor of state and the term of its appointment is 5 years. It shall be the duty of Finance Commission to review the financial position of the Panchayat and make recommendation to the governors. It make recommendation to the governors on the basis of few principles. These principles include the distribution between the state and Panchayat, the net proceeds of taxes, duties, tolls, fee leviable by the state, the determination of taxes, duty, tolls and fees which may be assigned to or appropriated by the Panchayat, the grant and aid to Panchayat from the consolidated fund of the state, the measures needed to improve the financial position of the Panchayat, and any other matter referred to the Finance Commission by the Governor. So now we will look at the elections to the Panchayat. इस आर्टिकल के अनुसार the superintendence, direction and control of the preparation of electoral rolls and conduct of all elections to the Panchayat shall be vested in a state election commission. इसका अर्थ है कि पंचायतों में चुनाव के लिए स्टेट इलेक्शन कमीशन की स्थापना की गई है जो कि कंसिस्ट होगा स्टेट इलेक्शन कमिश्नर से और स्टेट इलेक्शन कमिश्नर को अपॉइंट करेगा उस राज्य का गवर्नर। स्टेट इलेक्शन कमिश्नर की टर्म्स ऑफ सर्विस को गवर्नर डिसाइड करेगा। इसके साथ साथ द स्टेट इलेक्शन कमिश्नर शैल नॉट बी रिमूव फ्रॉम हिज ऑफिस एक्सेप्ट in like manner and on like grounds as judge of a high court.